in divorce by mutual consent whether the minimum waiting period of 6 months for second motion as prescribed under section 13V clause 2 of the Hindu Marriage Act can be waived off. In 2017, in the case Amardeep Singh versus Hardeep Kaur, the Honorable Supreme Court held that the minimum waiting period of 6 months as prescribed under section 13B clause 2 of the Hindu Marriage Act is not mandatory but directive in nature. In the case Amardeep Singh versus Hardeep Kaur, the Honorable Supreme Court considered on 2 points. First, whether the minimum waiting period of 6 months as prescribed under section 13V clause 2 of the Hindu Marriage Act was the mandatory or it could be waived off under certain circumstances by the court. Second, whether it is appropriate to use the Article 142 of the Indian Constitution to waive off the statutory term as set forth in section 13B clause 2 of the Hindu Marriage Act. And finally, the Honorable Supreme Court in the case Amardeep Singh versus Hardeep Kaur held that the provisions relating to the minimum waiting period of 6 months prescribed under section 13B clause 2 of the Hindu Marriage Act is not mandatory but directive in nature and could be waived off under certain circumstances by the court. These conditions are as: first, the statutory period of 6 months as prescribed under section 13B clause 2 is in addition to the statutory period of 1 year under section 13V clause 1 of the Hindu Marriage Act. It means the first motion filed after the 18 months of the separation of the parties. Second, the parties have genuinely settled all their disputes including alimony, custody of the child, maintenance, property, any other issues between the parties. Third, all efforts of the mediation, conciliation, including the efforts to reunite the parties have been failed and there is no likelihood to succeed in that direction by any further efforts. Fourth, the waiting period only prolonged their agony. The judgment of the Honorable Supreme Court in the case Amardeep Singh versus Hardeep Kaur is to be considered a landmark judgment and set precedent for the other courts with regard to it, declaring that the cooling period is directive in nature and could be waived off under certain circumstances.